You have legal questions. Amy the attorney has the answers. Welcome to today's show. And here's Amy.
Hello, and welcome to Amy the Attorney YouTube channel. We are so glad you joined us today. We are very happy to have Eric Dirks on today. He is a lawyer in Kansas City, mainly working on plaintiffs' cases. And today he is going to be talking about, there's a couple different terms I've heard for it, wage theft, paycheck theft. I've heard wage and hour cases. So I want, Eric, if you will give me a simple explanation of the kind of cases that we're talking about today.
Yeah, there are two primary types of cases, and those are minimum wage and overtime cases. So that are what they sound like. Minimum wage, I am supposed to be getting paid a certain minimum wage, but I'm not getting that. It may be clear on my paycheck, it may not be. Then the other kind is overtime. There are a lot of types of cases where folks are entitled to overtime pay, but they don't receive it. There are other types of cases where maybe they receive some overtime pay, but they're not receiving enough.
Okay. All right. Well, let's just jump right into the minimum wage case. How would someone know they are not getting paid the wage that they are supposed to?
Yeah. And like I said, it's not always obvious. There are probably 90% of the cases that come to us, the client doesn't know if they're getting paid right, but they think something smells fishy. So what we do is we take a look at their pay stubs, we take a look at any other documents they have, and we kind of know what to look for. So, for example, there could be a classic case of somebody's just not paying me for all of my hours. And if you multiply the wage that you're receiving by all of the hours worked, it brings it below the minimum wage. But a more common situation, there's probably two more common minimum wage situations. The first one would be somebody who's been classified as an independent contractor. So they're receiving a specific wage, but once you do the math, you realize once they're paying for gas, once they're paying for repairs to their car, et cetera, for tools, it brings them below the minimum wage once you do the math. So that's a very common type of minimum wage theft. Another might be servers or bartenders who they're able to be paid less than the minimum wage so long as they get to make that up in tips. But there are a lot of technical rules where if you're spending a lot of your time as a waiter, cleaning tables, putting bread baskets together, doing other things like that, it actually means the employer has to start paying you full minimum wage. So it can be technical, but it usually starts with somebody saying, hey, this doesn't seem right. This doesn't seem fair. I'm not making as much as I thought I would. And then from there, we take a look at the documents.
Now, let's talk about the servers and bartenders first. We're going to set aside the independent contractor for right now, but the servers and bartenders and other people, are these people, is this the kind of worker that clocks in and out, or do they write their time card? What is the normal, if there is a normal situation?
Yes, the vast majority of servers usually use a traditional time card that they swipe, or a time punch. That's getting a little bit outdated, but there's a time clock where they swipe in and they swipe out.
Okay. And is some of the cases that we're talking about here, are they being asked to work after that swipe is taken? Or are they asking to be worked before or after they've punched in?
Yeah, that's a great question. So the cases where somebody, and I've got some great examples of these, but the cases where somebody actually has to do some work before they clock in, those are called off the clock cases. So for servers and bartenders, that's not exactly what's usually happening, although we've seen it happen. The primary situation for a server or bartender is I've clocked in, now I've got to go do 2 hours of cleaning or prep work. It's in the industry often called side work. And I got to go do this, and I'm not even able to make tips during this time period. And so the rule is if I'm a server or bartender and I'm spending more than 20% of my shift doing these things like cleaning and prep work and side work, then all of a sudden I'm really doing too much. So I can do a little bit and they can still pay me that reduced minimum wage. But once it hits 20%, which, is about an hour out of a 5-hour shift. Now you got to start paying me full minimum wage for that time that I'm working.
Okay, so even if say, okay, I had to do an hour, I have a 4-hour shift, I did an hour's worth of side work, and, heads up, I did wait tables for 13 years, so I know a little bit about that. But can they make up in those 3 hours where I'm waiting tables, say like, okay, you know what, I had, seven tables, and I got paid, I got tipped $10 on each of them. So in that 4-hour shift, I did make $70, but the first hour was spent on side work. Does that make sense?
Yes, they can't do that. Okay. So even though I might be making a much higher than minimum wage overall, once I've added in my tips, if I'm doing more than 20% non-tip producing work, that means that the time I'm spending doing that non-tip producing work has to be paid at the full minimum wage.
Okay.
No matter what I made.
Okay. And I want to kind of walk this through a little bit. So somebody is waiting tables. They're getting an hour's worth of side work. It's a 4-hour shift. What are the steps? I mean, how would they, when they came to you, what would they bring with them, or what information would you need?
Right. Very little, frankly. One of the things about wage and hour law is you don't have to show up with a bunch of documents. You don't have to show up with a bunch of evidence. You have your testimony. You have your story. And in wage and hour law, that's typically enough, because the employer has the burden of making sure they're paying their employees right. So if you come forward and you say, here's what's happening, that's usually enough for us. And then we, the lawyers, we go out and we get the documents that we need to get. We get, in fact, one of the things in the server cases that we use a lot of is the point of sale records. So we can actually take the computer records and we kind of know what you're doing. In other words, if you're clocked in, but you don't have a table for 2 hours, we know that by looking at the point of sale records. So it's not something that our clients necessarily need to have. We can go get that.
Okay. All right. So you said that there was this 20% rule. Is that something that an agency of the government, says you can't do 20%? I mean, who is saying this 20%?
Right. So this has been a topic of a lot of litigation over the last 15 years or so. And so it originated from the Department of Labor had a rule that if a Department of Labor investigator came out, they'd say 20% seems about right. But what happened is courts started looking to that, and they said, yeah, this 20% rule seems like a reasonable way to prove your case. So it does depend which court you're in, but the courts around this area, the Kansas City area, have followed the 20% rule, and it's pretty much good law at this point.
Okay, with this paycheck theft, with these cases, do they all sort of follow the same path in terms of when they come to you and they hire you, or is the independent contractor case follow a different case than the servers and bartenders or off the clock cases?
In terms of how the case originates?
In terms of like how it goes in terms of suing somebody and what the client would expect to go through. Is the process similar? Are they different for all three of those cases?
It's pretty darn similar. So the process is, through a variety of ways, the client finds themselves to our office, and usually they don't know for sure whether there's a violation. And sometimes they've come to us and they're complaining about being treated unfairly in a different way. And we say, well, the law doesn't really protect you there, but where it does protect you is I can see you're being paid incorrectly. But yes, in terms of we look at the case, we talk to the client, we realize there's a case, they all play out pretty much the same way after that.
Okay. All right. Well, then we're going to get to later what that process is, but I want to go further into independent contractor cases and sort of how they materialize and what they look like. If you're an independent contractor, what would you be looking at?
Okay, so the independent contractor cases are a growing percentage of the wage and hour cases, and that's because employers have started they've stopped paying people as a regular W-2 employee, and they've said, hey, we can offload a lot of costs, a lot of insurance, a lot of pay if we just magically call you an independent contractor. So it's become a real issue. There are a ton of people who are independent contractors or classified as independent contractors who, under the eyes of the law, really should be W-2 employees, which means they are entitled to overtime and minimum wage.
Okay, so tell me about what happens with the independent contractor. Give me an example.
Okay, so a great example, because this is happening every day, would be, for example, I have a case right now of truckers, over the road, semi-trailer drivers. And so what happens is they'll start out working for a large trucking company, and then one day the trucking company will come to them and they'll say, hey, you want to be your own boss? Then come buy one of our used fleet, buy or lease the truck, and then we'll pay you more per mile. And so they think it's a great deal. They sign up for it, and it's rarely a great deal, because what happens is once I take my monthly pay or my mileage pay, and then I reduce the cost of the truck, the cost of fuel, the cost of repairs, there are months where I might make zero, literally $0 an hour or $1 an hour. And so if I'm an employee, obviously the employer can't offload their overhead on me. And so I should at least be getting full minimum wage for all the hours I worked.
Okay, that is an excellent example. So it doesn't, you say, if an employer says, hey, but you're an independent contractor, there are ways to say, well, right, but you're still not paying me the minimum wage.
That's right. So the first step in the case is to go prove that, hey, I'm not an independent contractor under the eyes of the law. So that's where the big disagreement usually is. And it comes down to factors such as, is this my full-time job, or am I a true independent contractor who goes and does work at different types of workplaces? It asks, how much control does the employer have over me? Can they tell me where to be and when? Or do I have complete control over my day or my week? Where do I get my business? Does the employer give me the business, or do I actually have a real business where I'm out getting work from lots of different places? So there are multiple factors, but what happens is the court or a jury will say, yeah, I think you fit more in the independent contractor bucket, or yeah, I think you fit more in the employee bucket.
Okay. All right. So let me ask you this. It sort of sounds in our sharing economy. I mean, you're describing some of this and I'm thinking, oh gosh, is this Uber and Lyft? There's been
a ton of litigation with Uber and Lyft and these other gig economy type workers, frankly, to mixed results. The biggest issue has been arbitration agreements. So companies who have rolled out an arbitration agreement that has a waiver of your class action rights, they've been able to keep individual cases, been able to keep us from consolidating thousands of cases together. And so we've got to go bring the case one by one. So that's been the big issue in Uber and Lyft. But yeah, that's a classic example of, all right, well, they're out. The employer says you're out running your business. You're working when you want. The employee says, yeah, but I'm working all through you. I'm getting my business through you. You're telling me what I can do, what I can't. And so the Uber and Lyft cases are great examples of the different kinds of questions out there. One of the things that I point out about Uber and Lyft is a lot of these guys are very part-time. And so if you find yourself working full-time for a company and they're calling you an independent contractor, there might be a problem. Okay. If you're working full-time and relying 100% for your income from one company, you're probably not an independent contractor. Right.
Okay. That's interesting step. All right. So now we're going to go to off the clock cases, and tell me what an off the clock case looks like.
Yeah. So an off the clock case is really the traditional wage theft, where an employer is actually not paying you for all the time that you're there working. So a great example, several years ago, I was able to try one of the first class actions in Kansas federal court, and it involved off the clock. And so the case was about donning and doffing, and that's a fancy term for putting on and taking off clothes and protective gear.
Okay.
This was at a meatpacking plant. And so what happened is these folks, they work really difficult jobs under brutal conditions, but it's also dangerous conditions. So they have to come in, and they have to come in early before their shift starts, and they've got to literally change out of their clothes, change into a new sanitary type gear. But they also, a lot of them have to put on protective gear as well. So it can take time between putting that gear on, taking your old street clothes off, and getting out to your workstation. It can take upwards of 10 or 15 minutes a day. And that was time that Tyson was not paying for. And it's very common in these types of industries to not pay for that time. But what the law says is once you start your first integral and indispensable activity, and I know that's a little legal mumbo jumbo, but once you start essentially something that you have to do for your employer, you don't really have a choice not to, that starts your workday. And the time clock should start there, and it should stop when you perform your last important task.
Including taking off the protective gear and getting back in your street clothes.
Yes, it can include that. Part of it depends on how long it takes. But in that case, for example, we were asking for time at the beginning of the shift and time at the end of the shift. Absolutely.
Okay. Do you see these cases in retail? Does retail have any presence in these cases?
Yes, it happens a lot in retail. I would say that the retail industry has done better at paying these folks right in that aspect. One of the places where retail's had problems is in misclassification of assistant managers. So they will have someone who mostly works at a cash register or something else that is definitely overtime eligible. But then they may have a few managerial tasks as well. And so if they're truly a manager, they don't get overtime. But if they're really more of a frontline worker with a few additional tasks, they should be getting overtime. So we've seen that more in the retail industry.
Okay. So say you are working in retail, someone's working in retail, and their boss, they close at 9:30, but they have been told the expectation is that they wait this is a male, but they wait with the female workers until the female workers get picked up. Nobody's driving. So the expectation is that, you wait until, so it's usually another half hour or so. And that's the expectation, that you wait with the female workers until they get picked up. Is that wage theft?
Most likely. It might depend on some of the facts. For example, if just a chivalrous male employee decides on his own to wait, he hasn't been asked to do that, but he just does it, and he's really not asked to do it, and the employer may not even know he's doing it, that's probably not wage theft. If the employer knows it, especially if the employer says that's the expectation around here, then I would say absolutely that's wage theft.
Okay. All right. Let's dive a little deeper into this salaried manager position and getting paid an hourly. Talk a little bit about that situation and what you've seen.
Yeah. So that's kind of the next big category is somebody who is being paid on a salary. So and it may be a good salary, by the way. There are a lot of folks who make very good money, and they're generally happy with that amount. But that's not what the law looks to. The wage and hour laws don't care what your deal is with your employer, because the wage and hour law sets minimum standards. So folks who are paid a salary, this is the thing that probably surprises my clients the most. If you're paid a salary, it doesn't mean you don't get overtime. So you can be paid a salary and overtime eligible. And that can include folks who are kind of high-end IT workers, depending on what their duties are. It can be bankers. It can be folks in the insurance industry. And it can be those retail folks that we were talking about who are called managers, but really don't have manager responsibilities as their primary duty. So there are lots of jobs out there that are good, either called managerial or white collar jobs that are absolutely entitled to overtime. And those are called misclassification cases.
Okay. So the spectrum of your clients can be anywhere from minimum wage to a much higher salary. This is not necessarily minimum wage workers that you're representing.
That's right. I mean, a lot of times it may be just because of the nature of the industries, and a lot of industries are trying to save on margins, and a lot of times they do that with folks who are closer to the minimum wage range. But absolutely, we have cases where individuals are in a very, what you would consider, good job, making good money, but they might be working 60 to 80 hours a week, week in, week out. And it turns out they should be getting overtime for that.
Okay. What is the difference between exempt and non-exempt employees?
So, those are big words for I'm entitled to overtime or I'm not entitled to overtime. So the law divides folks into two categories. Exempt means I'm exempt from overtime. In other words, the employer doesn't have to pay me my overtime. Non-exempt means I get paid overtime.
Okay. And we haven't really gone too much into this. You're licensed, obviously, in Kansas and Missouri. Are the laws similar in those states? Is it one law that's overreaching both, or is it specific to the state?
That's a great question. So typically when we bring these cases, we're bringing it under what's called the Fair Labor Standards Act, which is a federal law. And so it applies the same in Missouri and in Kansas. And we have to bring those cases in federal court. Although the state of Kansas and the state of Missouri also have their own, what I would call little FLSA, little Fair Labor Standards Act statutes. And so sometimes there may be strategic reasons to bring it under the state law instead of the federal law. But essentially,
that's something that you would be talking to your clients about, how you're going to bring the case, et cetera.
Absolutely. And if a client's interested in learning more, the FLSA, the Fair Labor Standards Act, is the place to start. The state laws may be slightly different, but they really are modeled after the federal law.
Okay. Can you give us a general, what is FSLA overtime? I mean, tell me that.
Yeah, I think this is the thing that most people are familiar with, which is the federal law says if you work 40 hours a week, that's fine. But once you start working people more than 40 hours a week, now you've got to pay them time and a half for those hours. So that's pretty well known, and it's really that simple.
Okay, so your cases are about people that are not being paid what they're supposed to be being paid. But simple.
Absolutely.
Yes? Sorry.
Yes.
Okay. Okay, so somebody comes to you and now you've determined, hey, there's a case here. Can you kind of tell us exactly how the case is going to go, like how long it's going to be? I'm sure it differs between a lot of different cases, but just give us an idea of how it goes.
Sure.
And the follow-up question is going to be about whether they're still employed while the case is going on, because I want to talk about that and how that works out. But just guide us through a client journey right now.
Okay. So it would usually start with a meeting where my client will show up with pay stubs or maybe an employee handbook, any documentation that they have in their possession. I usually ask them to bring it in. It can help me out a lot. But again, like I said earlier, you don't have to have any documentation because really your testimony is enough in these cases. So the client will come in, we'll talk about what the options are, we'll talk about whether there's a case. A lot of times we'll talk about whether there's a class action component available. It makes a lot of sense to bundle these cases up together. It brings an efficiency of scale for us to be able to do the work even if it's just, a little bit here and there for every individual, where it may not make sense for a lawyer to represent somebody who's only getting ripped off 5 minutes a day. If you extrapolate that over 1,000 people, now all of a sudden it makes economic sense for everybody to pursue it. So we'll talk about those types of things. We'll talk about the claims. We'll talk about how comfortable the client is with pursuing the case. And assuming that all that pans out, we'll go and file what's called a complaint in federal court or a petition in state court. And that's us suing the defendant or the employer. And once that happens, these cases never get done in the first few months. I would say it's usually they resolve somewhere between a year and upwards of 5 or 6 years, although that's not the norm. I'd say the average is 1 to 2 years. And so in the meantime, we, the lawyers, are doing a lot of paperwork and filing briefs with the court and arguing with the lawyers on the other side. But the client, oftentimes, there's not a lot for them to do. So they're kind of waiting around, and sometimes I say, you may not hear from me for a couple months. Rest assured we're working on your case. But once we file that complaint, then the next thing that our client will be doing is, and probably already has done, is gathering any documents that are relevant to the case. And they usually brought those to the original meeting. So we're talking about things like pay stubs and employee manuals. And so we give that to the other side. And most of the time, the other side will want to take the deposition of our client. And so that's usually somewhere between 4 and 6 hours. And it's very factual. It's how long did you work here? What did you do? What hours did you work? And it doesn't get into sort of the law and order, he said, she said type of you can't handle the truth moment. These are very factually based cases, and there's not a lot of intense moments. So then after the deposition, then there's a lot of work that the lawyers are doing on the back end. And usually the next thing to happen is a mediation where we try to reach a settlement. And that may happen close to the deposition, or it may happen a year or two later. But those are really showing up, meeting with me, giving me your documents, and usually giving a deposition. Those are really the big things that the client's doing. But probably the biggest thing they're doing is waiting on us to get the case to a point where it's either ready for trial or ready for settlement.
Okay. When you say deposition, a deposition is like an interview that the other lawyer, the lawyer for the company that this person may still be working for, is going to be interviewing them, right?
That's right. I think one of the biggest misconceptions my clients have is this is going to feel like a courtroom or there's going to be a jury there. And it's the exact opposite. It's usually in my conference room down the hall from my office, and it's a lawyer for the other side. It's me there to protect my client, and then there's a court reporter taking down everything. But there's not a judge, there's not a jury, and it is very calm. It's very relaxed, and 99 out of 100 of my clients walk out of there saying, "Okay, that wasn't as bad as I thought it would be."
Okay. And so would you get somebody ready for that interview? I mean, do you prep your client before that?
Absolutely, we do. And it kind of depends on the client's comfort with the situation, what the facts of the case are. But most typically we'll set aside the day before the deposition to sit there and talk with our client about, here's what a deposition is, here's what to expect, here's the right way to respond to questions. In terms, it's not a conversation like you would have in the real world. It's a little different. So there are different techniques.
Okay. All right. We talked about the overtime for salaried employees. So when you decide, okay, we're going to, this is it. How do you get paid?
So most of these cases are typically class actions or a group of people bringing the case. And under those circumstances, the court actually awards my fee. So it's typically like a percentage of whatever my clients recover. So it's kind of like the TV commercials that people are used to hearing, that you don't have to pay me unless I recover money for you. That's exactly how it works in these cases. But then there's usually another step of the court looks at the work we did, the court looks at the recovery we received, and then says, this is the right percentage that you should be paid. So it's usually a percentage of the total recovery, and it's usually something that's been approved by the judge in the case.
Okay, so the court determines that number.
In a class or collective action, the court determines it.
Okay. And so we talked about this deposition, this interview, you doing your other work. Would a client have to come up with any money for you to do that work?
No. So we cover all the costs, and sometimes they can be significant. In larger cases, we have to hire experts to analyze data or to calculate damages. We're oftentimes dealing with millions of rows of data. And so we'll bring in a statistician or a computer individual. But anyway, we cover that cost. We cover the cost of depositions. We cover the cost of our travel. We cover everything. And then at the end, if we're successful, then the court will give us those costs back out of the total recovery. But our clients never have to come out of pocket for fees or costs.
What if someone is continuing to work for the company after you have signed them up to be a client? What are the pitfalls? Do they feel weird? How do you counsel them?
This is probably one of the top 3 most common questions we get from our clients. If they're still at their same employer, they say, what's this going to look like? Am I going to be in trouble? So, this is a highly personal question, and everyone has to make their own decision. But what I will say is there's a law. Part of the Fair Labor Standards Act says it's a complete and utter no-no for the employer to change anything or to retaliate in any way. And so my experience, I've been doing this for over 10 years. My experience is sophisticated employers with good lawyers never retaliate. They get good advice to just leave it alone. It's very rare to see any type of negative treatment toward a client. And when it does happen, it's usually a very unsophisticated, small company that has a lawyer giving them terrible advice. But what I tell my clients is it's not going to happen. If it does, I'm going to sue your employer for that. And all of a sudden you have a better case for retaliation. But at the end of the day, it's a personal choice that my clients and their families need to decide.
Okay. Is there a minimum number of employees that you have to work with or that the company has in order for you to be able to sue them? Can you sue somebody that is the owner and has 1 employee?
That's a great question. So some of the employment laws have a actual number of employees as a sort of requirement. In the Fair Labor Standards Act, the requirement is that the company does interstate commerce, which is usually everything, and has revenues of $500,000 a year. So it doesn't look to the number of people. It just wants to make sure they're not, a very small mom and pop business that really doesn't have a lot of revenue.
Is there any remedy for somebody that's in that situation with the mom and pop situation?
What I would tell someone who's in that situation would be to contact the state or federal Department of Labor. So they are massively under-resourced. They can't bring a lot of cases, but they do especially look out for folks in that situation who aren't getting paid right by a small company.
Okay. I want you to walk us through a case. Give me a case where somebody came to you, felt like there was something fishy going on. Just walk us through a case.
Okay. I'll walk you through the case I referred to a few minutes ago because it actually went to trial, so it might be more interesting than the 99% of cases that resolve in settlement. Although, like I said, most of them do resolve in settlement, and that's usually best for everyone. This case was pretty unique. So I had a client, Adelina Garcia, who was working in Garden City, Kansas at the Tyson meatpacking plant. And she and some others came to us and said, we don't think we're getting paid right. So this was exactly like what we were talking about earlier, where they didn't know the law. They didn't know what their paychecks really reflected. In fact, their paychecks were very complicated. But they said, we think something's wrong here. Will you take a look into it? So we looked into it. We met with numerous workers to ensure that everyone was being paid under the same policy. And what we found out was, while they were probably spending 15 to 30 minutes doing this changing of clothes and putting on protective gear, they sorry, I lost my train of thought there. While they were putting on the protective gear and spending 15, 30 minutes of doing that, they weren't getting paid for any of it. Well, that's not entirely true. The company had previously been sued for the same thing. And so what they did is they started paying individuals 4 minutes a day extra for this changing time. And so what our case was about was really, how much time does this actually take minus this extra 4 minutes of pay? And so the case progressed. Several individuals were deposed by Tyson. We took several depositions of folks at Tyson. Both sides had multiple experts. Some of the experts actually went out to the plant and recorded what people did, coming in, changing, going out to their spot on the line. It's called a line. Just as an aside, meatpacking plants are very interesting. They're kind of the opposite of an assembly plant. They're really a disassembly plant, and so the meat moves around and it gets sliced up more. Anyway, but the experts went out, they did their analysis, and they say, for both sides, it takes X amount of time to do this, it takes Y amount of time to do this, and then we have the testimony of our clients. And so in a rare case, the case actually went to trial, and it was in front of the federal district court in Kansas. And we got a plaintiff's verdict, and it still wasn't over. There was 2 years of appeal after that. So I think we filed the case, and this is the extreme example by far. We filed the case in, I think, 2006, and I don't think it was fully resolved until 2012.
Wow. Yeah. So it could take a while.
Yeah, but that is definitely the outer kind of limit. I'd say 1 to 2 years is most common.
So when we're talking about the money that a potential client can get, is it just the missing time? Is that the only thing, the missing money, is that the only thing they're entitled to?
No. So unlike most lawsuits that people have heard about, you're not entitled to punitive damages in a wage and hour case, but you are entitled to something called liquidated damages. So if you take the case to trial and you win, and let's say you recover $1,000 in missing wages, there's something called liquidated damages. And so essentially it doubles whatever the jury decided you were underpaid, it doubles that amount. There are some specific defenses to that a defendant can raise, but I would say that's generally the rule, that it can be doubled if you win a trial. On top of that, the employer's got to pay my fee and my costs. So it's not coming out of the recovery from the client if it goes all the way through trial.
Okay, good. And we talked a little bit about this with servers and the chicken industry. Are there other industries that are common for these kind of violations?
Yeah, that's a great question. There are, and it kind of changes. So over time, you might have one industry and they start getting sued a lot, so they change their practices. So 10 years ago, it was the banking industry with their loan officers, but you don't see that as much anymore. So today, you're seeing a lot of the independent contractor misclassification cases. So folks who are delivery drivers, folks who are truckers, folks who are installing cable. There's all kinds of individuals who have been called independent contractors, but it's really their full-time job, and it's misclassification. So I'd say that's kind of the big one right now. The servers and bartenders is also big, but they're starting to change their practices. We started doing those about 5 years ago, and at that point, all the restaurants were getting it wrong. Now, at least the larger restaurants that have multiple locations are starting to fix their problems. So there's always some new emerging industry. The other one is oil field workers. We see that more in Kansas than in Missouri. These guys are out there working a lot of hours and they're not getting paid any overtime. So I'd say those are the three big. Let me add one more. I'll give you four big. The fourth is IT workers. So someone who is a computer engineer or a full program analyst, those people are absolutely not entitled to overtime. But what about someone who's a very entry-level individual, may not even have an IT degree, but what they're going in is doing very low-level IT for a software company? Those are cases where they're entitled to overtime, but they're not getting paid it because their job title sounds fancy, or they may use words that people don't know. And so people think, well, that must be, really technical, when in fact it really doesn't take a technical background to master.
Okay, good. What is there any intimidation factor against going against a big company? I mean, you said Tyson, and I think, oh gosh, they've got lots of lawyers, they've got lots of money, and it's just, it would just be me and I'm against them. How do you counsel your clients in that scenario?
Sure. I tell them, we've taken on dozens of the top largest countries. Let me try that again. We've taken on dozens of the largest companies in the country, and me and most of the folks I work with actually used to represent big companies when we first started practicing. So from the lawyer aspect, there's no intimidation factor. Usually the big companies hire good lawyers, and I prefer that, because at least, we're arguing about the right things. So there's no intimidation factor on the lawyer side. And I tell the client, we'll take care of you. Don't worry. Just tell your story, tell the truth. And I like your case. I think you have a case. Let me go deal with it. And so there should be no reason that our client should be intimidated by the other side. If anything, they're hiring good lawyers who are going to treat my clients with respect.
Okay, good. I'm going to ask you another question. What is the FLSA exempt test?
Okay, that's a great question. It gets a little complicated because there's more than one. Okay. So there are different exemptions under the FLSA. There is a professional exemption. So people like doctors, lawyers, teachers, those folks are exempted. And that looks to the course of study that someone went through. And it has to be an advanced course of study. There's here's a good one, the outside sales exemption. So that means somebody who's a traditional salesperson outside of the office. It really originated with people knocking on doors like the Fuller Brush Man. But it could be anybody who's out doing deals or knocking on doors. So they're exempt from overtime. There's the executive exemptions. So there are several of those. There are different tests. One of the tests would be, do I manage 2 or more workers? That's one of them. Another one would be, am I doing the type of job that's managerial, even if I don't necessarily manage other workers? Am I doing something that's administrative in nature? So am I doing taxes? Am I, in charge of the IT? Am I sort of running some aspect of the business or providing specialized advice to the business? So those are some of the big ones. There are other random ones like agricultural exemptions. There are exemptions for certain types of firefighters and police officers. So when someone comes to me, that's one of the first things we have to do is figure out, do you fit in one of the categories of workers who really, truly is exempt, or do you not? And typically, if they're coming to see a lawyer, they're probably a little bit in a gray area. That's the most common, unless their employer is just willfully violating the law. A lot of times it might be that it's a new type of industry. And that's why I mentioned computers. They haven't been around forever. And so figuring out who's exempt and who's not is something that hasn't been fully vetted with courts and juries.
Okay. Is there a question that I have not asked you that you think people should know?
Although it's not the most interesting topic, one of the first questions I ask my clients is, do you have an arbitration agreement? And this wasn't even a question 10 years ago. But now, given a series of United States Supreme Court cases, it really matters a lot. And so that's something that any client who's coming to me, I'm going to ask them. And believe it or not, most people don't know. I wouldn't know either, because it's usually hidden in a big stack of documents that you sign on day one. But it's something we have to figure out. So if folks see those, they should take note. If they have a choice to not sign it, I would say talk to a lawyer or don't sign it, because it really, what it's doing is it's eliminating your right to a trial. It's eliminating your right to go to court. And instead, you're having your case decided individually by another lawyer who's being paid by the employer.
Is it a case killer? Will if they do have an arbitration agreement or arbitration clause that they've signed away, is it usually means that you can't take the case?
Not necessarily. We still need to have some economies of scale. The problem is if somebody has a case that maybe they could recover $500 or $1,000 best day in court, it makes it really hard for us to bring that case individually. But if there are 30 other workers who are in the same place, we can file 30 arbitrations, and we have the efficiency and the economy of scale. So it really comes down to, are there enough folks with the similar kind of claim? Then absolutely would bring it. If it's just one client who has a one-off situation, a lot of times we say it probably doesn't make sense to go full-blown litigation. Sometimes we'll write a letter to that employer, try to get them their money back. That works half the time. Sometimes we'll tell them to go to the Department of Labor, because it's more of that mom and pop situation, and that can be effective as well.
Okay. Arbitration agreements, if you don't have to sign one, don't. But sometimes they can make it a condition of employment. Absolutely.
In this day and age, you probably don't want to make a big fight of it with your client or with your employer. If they're making you sign it, we all know you kind of got to sign it. But if you ever do have a choice, I would take a long, hard look at it. And I personally wouldn't sign it.
Okay, but you're exempt, right?
Exactly.
Okay, so I want to get into a little more fun stuff. If you have somebody visiting from out of town, where would you take them in Kansas City? I'm not talking about restaurants yet. Just in Kansas City, where would you take them?
Is it a client? Is this a formal?
No, it's your family friends. It's your family.
Okay. Well, the first thing I'd probably do is drive them through the corridor. So I'd take them from downtown to the Crossroads to Westport, make sure they see the plaza in Brookside. So they kind of get that's sort of where I live most of my life. So they get a good sense of that. And I know you said not talking about food, but it's hard to not mention food if somebody's visiting Kansas City.
Yeah, exactly. Well, what's your favorite barbecue in Kansas City?
So it depends what mood I'm in. I would definitely take someone from out of town to Arthur Bryant's. I'd definitely take someone from out of town if they're looking for a little higher end experience to Char Bar, maybe Q39. And then a lot of folks, they've got to try Gates. Although it's not my personal favorite, it's a pretty fun experience.
You're very open to all of them.
Absolutely.
You're old school and new school.
Exactly.
What non-barbecue restaurant is your favorite in Kansas City?
Boy, that's a great question. I'd have to say on the sort of the high end, fancier kind of restaurant, I don't think you can beat Corvino. It may have leapfrogged over Le Fou Frog for me. But any restaurant on 39th Street, I'm down with. Awesome.
All right. Can you give everybody your contact information? And we'll also have that linked in the YouTube notes below. We'll have it linked on the screen, but go ahead and give everybody your contact information now.
Sure. Eric Dirks at Williams Dirks Dameron. We're at 12th and Main at 1100 Main Street. The best way to contact us is email or phone. My email is my last name, Dirks, D-I-R-K-S, at williamsdirks.com. And my direct office line is 816-945-7165.
I just thought of another question having to do with how do people get to you? How do people get to you?
So there are several ways. I can think of three off the top of my head. First one is another lawyer who doesn't practice this area of law will call me and say, hey, is this a case? That happens all the time. The second is someone who was a class member in another case. They didn't really participate, and then they got a check in the mail for $1,000 one day. And so those folks will often call and say, hey, I worked at another place that was doing the exact same thing. Is there a case here? And then the third place is someone who maybe has a discrimination or harassment type other employment dispute. And they may have a case, another employment case, or it may not actually be a case. But through the intake process, we realize they're being paid incorrectly. And we'll talk with our client about that and see if it's something that they want to pursue.
All right. Well, thank you so much for joining me. I appreciate it so much. Thank you all for listening and watching. I hope you learned a lot. I know I did too. Everyone have a great day.